So, my lovely greetings to all the brilliant students who have joined this discussion group today, this evening. I also feel privileged that I have been invited by you I am also happy that I attended the opening ceremony of this university in the year 1999 when the university was inaugurated. And I got the opportunity to attend the seminars which was held here, and chief justices of different high courts or their nominees attended the seminars. The seminar was conducted for 3 days. I was benefited by it. I was thankful to Justice S.K. Sen, the Chief Justice then of Allahabad High Court. The university motto of this juridical science is Yuktahine Vicharetu Dharma Hani Prajayate. Judgment without logic destroys dharma. Now, today the topic is religious values under the Constitution is certainly a subject which requires an investigation through logic. Religion is sometimes called dogma, a collection of doctrines. Some says it is a science. So everyone has a different view and different interpretations. You require a logic to understand it, its meaning, its sense. India is a vast country, and the census in 1911 shows that less than 0.5% did not give their religion, but everyone stated about his religion. So it means there is hardly any person in India who is atheist. Certainly, those belonging to certain party may proclaim, I don't accept religion or God or whatever it is. But everyone who is born in India is religious. Religious in the sense, the moment is born, the father or the parent will say, he is Hindu, he is Muslim, he is Christian, Sikh, whatever. The name is given, though the boy does not know it much. But even when it comes to certain age of discretion, he is known by religion also. He is not, nobody says that he is a man, he is a student, he is a child. But he will say he is a Hindu, Muslim, Sikh, Christian, whatever the name. He is a branded. So he is a religious without knowing the religion. In a different countries, that is not the position. In China, 80% people will say, I don't attach to any religion. Whether they believe it or not believe, that is a different question. They are not branded as belonging to a particular religion. So now what is the religion and what the constitution says about it? Now the difficulty arises. The people belonging to different religions have different doctrines, different faith, different systems. There is no difficulty about it. The difficulty arises. Their differences in respect of their thoughts, systems, and belief and faith. When they are put together, just like conglomeration, there is a difference, and that erupts sometimes to violence, just like putting certain people in a compartment of different religion, and if they talk together on religion, the differences arise, and instead of love, there is a hatred. Instead of brotherhood, there is a separation. Instead of helping each other, they set apart from far away. So India, with a vast majority, having different religions, having different people of different thoughts, it is the managing of affairs in respect of the religion. Even so far, politics is governed with a religion. The question is how the Constitution has helped us, how the Constitution has worked out, how this Constitution has found out any solution for it, or whether the Constitution is itself hodgepodge, created more problems. So you must have broadly to think it, find out the logic for it. As a lawyer, as a logical person, abstaining from your mind as to what type of the religion you belong to it. Firstly, in the Constitution, there is no definition of religion anywhere. Preamble of the Constitution says so many things, but it does not give the definition of religion. It says liberty of thought, expression, belief, faith, and worship. In the preamble, we secure the citizens of India freedom of it, so and so, liberty. The word religion is missing. Why? The framer of the Constitution knew that the religion, word religion, is interpreted differently by the religious people. They say they define their own way of religion. So if you use the word religion, the Constitution cannot define it. If they define Constitution, it will create problems. I'm not going in that whether what type of the definition should be. But the reasoning, I think, why religion has not been mentioned in preamble of the Constitution of India. It has not been Article 19, freedom of speech and so many, but the freedom of as a fundamental right in relation to religion has not been given. It is the first time under Article 25, Clause 1, the religion has been defined. Religion has been mentioned. But even that part is concerned. The very first part, it said, subject to health, morality, etc., and other parts of the Constitution. So you must have come across or heard about the judgment in Sabarmalai case, 2018, National Young Law Association of Kerala versus State of Kerala, where the writ petition was filed. The question was whether the women aged between 10 to 50 years could enter to the temple and offer their prayer. By custom, for thousands of years, I don't know what they did. They were not allowed. For various reasons, it is not necessary for me to go into that question. But the most important part of it constitutionally was the Supreme Court said Article 14 of the Constitution, 15 of the Constitution says that they have a fundamental right of equality. And because Article 25 says subject to the other provisions of the Constitution, so Article 14 and 15 will be applicable, and they have a fundamental right of equality on that basis of the equality clause. They have a right to enter the temple and worship and make offerings, whatever there. So it is a concept of equality as provided in the Constitution. This created controversy. The matter has been referred to, review petition was filed, and has been referred to a larger bench for the reason whether a fundamental right of equality can override the fundamental rights of the religious institutions. They have also a fundamental rights to preserve their customs, ceremonies, etc. Recently, in 2020, the Madhya Pradesh High Court, the petition was filed by women saying that Jain Tirthas are concerned, we can also offer water and abhishek. Ceremony can be performed by the ladies also. This was objected by Jain people, community people, said under the scriptures, custom, the ladies are prohibited to offer water, etc., Abhishek. So they cannot offer Abhishek. And this was upheld by the Madhya Pradesh High Court after referring to the case of Sabarmalai case. Now, this is a small part that I am considering. But you go this to a larger part. Many arguments are still hidden in it. That larger part, what I mean to say is personal laws. Now, tomorrow the question will be in respect of uniform civil code. On one side, the fundamental rights, the another says this is personal law. You cannot override. This is another aspect. Because in the Shah Banu case, this was also the argument. So all these questions, which are wide open now after Sabarmalai case. So one of the aspects under the Constitution is religion, another is fundamental rights as embedded in the Constitution. So these are some thoughts still require to be considered by the jurists, by the courts, and the lawyers have to prepare for themselves to put their point of view in different perspectives. Now, so far the question of another aspect was that I left was what the court interpreted in respect of the meaning of religion whenever the word is religion is concerned. In fact, none of the courts have defined religion. Etymological, the word religion is a word, the Roman word, came from their word elergy, religare. Religare is technically means to bind. Now they further went to bind. Bind means binding, bound with God. But supposing those who don't believe in the God, Buddhist, Jains, they don't believe it. So the Supreme Court says that bound means when there is no specific religion, believing in God or etc., they are bound by own inner conscious or super consciousness. So this super consciousness, say they bind it. But this is the interpretation of the word religion. But you ask some Christian, what is the meaning of religion? Some Muslims to say what is religion? He will define in a different way. So the religion has yet not been defined. It has been only a system of thought practice, and their performance and thinking. The next important part, everybody uses the word secularism. The word secularism was not there under the Constitution till 1976. It was introduced by 42nd Amendment in the Constitution in the preamble. Except preamble, nothing is there, everywhere. The question is why this word was added in the preamble. What is the reasoning for it? Durga Das Basu, the eminent constitutional expert, says that it was redundant, it has created more problem than creating any solution. He has given the reasons for it. In secularism means the state will have no its religion. There is a separation between the church and the state. That is the one meaning, secular. So if that is the meaning of the religion, secularism, that the state will have nothing to do with the religion, that this very concept was already embedded with the various articles under the Constitution. He has given the various important decisions. In Keshwanand Bharti's case, 1973, the very famous case, is the basic feature of the Constitution of India. What are the basic features of the Constitution of India? 1,000 pages written. But it is not necessary to go. But it was observed in that case, laid down the principle, so far, the basic feature of the Constitution of India is that the state shall not discriminate against any citizen on the ground of religion. Secularism, you want to discriminate on the ground, you don't discriminate on the ground of religion. This is secularism. Second meaning, then Chandrachud, the Chief Justice of India, in Indira Nehru Gandhi's case, said the state shall have no religion of its own and all the people shall be equally entitled to the freedom of conscience and all the people shall equally to freely profess, proclaim and propagate religion. So this was in 1975. So Dr. Durga Das Basu, in his book was 42nd Amendment Constitution and its impact. That addition of the word secular in the preamble of the Constitution is without any purpose and it has rather created more problems. The word secular has no meaning in the preamble of the Constitution. It does not solve any of the problems in respect of the religion. Instead of adding the word secular, it could have made a part, Article 15A of the Constitution, which says that I just put it in a second. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities. So instead of saying secular, which has no meaning, you want to say something in the preamble in respect of religion, you could have said promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religion. Transcend religion, forget the religion, or believe in religion, go above, beyond religion. And then it should be the harmony, the brotherhood. So what was the basic concept of the religion? An internal process of man, love, truth, non-violence. The people believe in religion, sitting together. Differences are there. So it requires a harmony. And that should be done. Now, another part, though the word secular is there, but it is a pseudo-secularism, Indian. Smith and various foreign authors, Indian jurists also said. The difference between secularism in Western countries and India is a different. If they are separate in religion, they are in real sense separate. The state does not interfere at all. But here the state interferes in every part of the religious matter. Not a single part is there which is not interfering. Here it says that no finance or any single penny of the state government shall be spent on any religious matters. But in fact, this is not so. Minorities have been given a specific status. They are provided fund. They are in the same, if it is controlled by if the state aids an institution which is not minority, it is fully controlled. But if the aid is given to minority institution, it is, of course, they say, use the word regulate, but no restrictions can be imposed. And finally, this matter was this. Not finally, you can say, many cases where the question arose as to the regulation or restriction. In Exeter case, the question was, if the law provided Gujarat University Act, there was a section 5. Section 5 provided that in minority institutions also, no teacher shall be removed, dismissed, suspended without a proper inquiry, and if he is dismissed, removed, suspended, or whatever the punishment is given, it shall be on the approval of the Vice Chancellor. The Supreme Court by majority held ultra-vires the provision of Section 5 it amounts to restrictions on the rights of the minorities. And it struck down that provision. So the net result is the state is funding the minority institutions. But it cannot control it at all. In that sense, the regulation is always subject matter of interpretation. What is type of the regulation? It is a full regulation. It is a restrictions. It takes out the total management's right. This is a different question. It has to be seen in a different cases in a different way. So I'm just pointing out how the state interferes in funding, financing, and interfering. So this is one of pseudo-secularism. Then again another aspect, free to manage matters of religion, Article 26B. The state shall not interfere in the matter relating to the management of the religious affairs or its properties. But in fact, it is interfering. I'm not saying rightly or wrongly. What is the Constitution is and how it has been interpreted. Now, many cases, many judgments, many. But one example you can see. In Puri, the Raja of Puri was managing the affairs of Jagannath Puri. He was everything in that matter. But the act was passed, and in that act, the rights were taken away. A committee was constituted, and it was totally, the management was entrusted to the committee. Of course, in the committee is the head of the king, is the Raja of Puri is head. But it is interference. In the Madras, in Tamil Nadu, almost every temple is under the government. It is a right or wrong, I'm not saying it. How much they are justified with the present time, its affairs. But I just want to show the nature of the secularism. They interfere. So every case when an act comes, it is challenged. Then again the question arose in Auroville case. Now Auroville case, total empire was there. Auroville, as everybody knows, in the Arvind Ashram. Thousands of acres, various institutions. There was a dispute. The management was taken away. The argument in the Supreme Court was that it is a religious institution and the management and its affairs cannot be taken away by an act by the government. The argument on behalf of Auroville was, no, it is not a religion. Aurobindo's philosophy was pure yoga, consciousness, super consciousness. That was the philosophy, and that was a yoga. And yoga is a science. It is not a religion. And the Supreme Court accepted that philosophy of yoga. Aurobindo was there, and therefore it is not a religion, it is a science, and the act is valid one. So all the affairs can be administered by the state government or its committee. So now, looking to the matter, the Ramakrishna Mission starts saying, no, I am not belong to any religion, I am not a Hindu. I have owned my philosophy, Vedantic philosophy. Vedantic philosophy doesn't mean any religion. It is universal. Then Supreme Court said, no. Vedantic philosophy is a Sanatan Dharma. You are a Hindu. And then they wanted, they should come out from the clutches of the government by controlling the government. They don't wanted that they should be controlled by the government, their institutions, but that was not accepted. So in the management of the affairs in the matter of religion, the state interferes it and the court interprets it. I'm not going to any decision, correctness, its validity, but only a working, a chain of it, looking at what the Constitution is in respect of religion. So this is the one aspect of the concern. Now then, religious education. Article 28 of the Constitution says that the state shall not provide any religious education. Now they have classified education, institution wholly maintained by the state, no religious instructions. But institutions recognized by the and not aided, unaided institutions, their religious instructions can be imparted with the consent of the individual. The third type of institutions, which are recognized and aided by the government, their religion educations can be imparted with the consent. Fourth type of institutions, suppose I have endowed certain property to the government and say you provide this religious education, they shall provide the religious education. The state is bound because once you accept the endowment, you must accept its conditions also. But the question is again, what is religious education? So, is Guru Nanak University was there, is still there in Amritsar. An act was passed, and that act made the teachings of Guru Nanak compulsory, life in his teachings to be taught. It was challenged again in the Supreme Court. Look here, it is a religious education asking the government asking the university to preach the teachings of Guru Nanak. He was a religious leader. The Supreme Court rejected the contention. Said Guru Nanak teachings was humanity. His life and teachings are for humanity. If it is for humanity, it is not religious. It's preaching. So if teaching in the name of the humanity, it is not religion. Then the most important case was Aruna Roy's case. Now, what happened there? A national curriculum of textbooks was prepared. And in that textbook, it was provided that the textbook shall contain the teachings of all the religious leaders so that the humanism, the thought of brotherhood may be taught in the institutions, colleges, and that textbook is a valid one. Again, it was challenged in the Supreme Court. Now the Supreme Court said, what is wrong with it? You are find out the best of the teachings of religious leaders, and that is necessary for the people, the students, to develop human relationship, truth, non-violence. So it is not a religious study. It is again what you teach. Is it religious or not religious? In the Bible, your 10th commandment is there, you put in a book. From Quran, you put certain good ideas. From Vedas, you put certain good ideas. For love, affection, humanitarian, brotherhood. So it is from different religions. It is not, because it is not doctrinal. So that is Article 28 of the Constitution of India. The question is, last in this strife, today the word religion, if you use it, it immediately strikes the mind. There must be some conflict, some differences. Only you can find out what are the religion in the sense, not its going philosophy. But it has 4 aspects. One, relation of man to God, or those who not believe in God, his soul to super consciousness. When everyone believes in soul, he is living, is a soul. Second is mode of worship, rituals and ceremonies. Third, cultural aspects, like festivals. I'm celebrating Holi, Diwali, one Eid, or so many things. But every religion has some outer fiction. Then fourth is their secular aspect, construction of temple, mosque, etc. Then establishment of school, hospitals, and other children. So they are all watertight compartment. Swami Vivekananda, Parliament of Religions, in Chicago expounded the theory that all religions are one. The mode of realization of the Supreme may be different, but just like different religions, ultimately see in the end. So whatever the way one practices his religion, But ultimate is meet the God, or you realize the super consciousness within yourself. But in practice, it is different. So he made a different story in his own species. One frog was there in a well. Another frog came inside, who was from the sea. He said, this sea is very short and small. They said, what type of the sea is? Then he went from this side to this side. It's very small. You have not seen the sea. No. This is to me, this sea. So he said, one well is for Hindu, one for Muslim, one for Christian. Everybody is in a well. None has seen the sea. So it is a totally confined to oneself. So what was a brotherhood doesn't seem ultimately, if you go into one tight compartment, you don't see the other is a brother. If you love, the love is limited to that people of religion. Brotherhood, it is limited to that. Non-violence, they themselves non-violent, but so many wars in the world, if they have fought out, they are in the name of religion. The world is now today, the map is concerned, the global map is prepared on the basis of the religion also. There is an atlas. The atlas is only for religious people in the world and where they are. I can think of some matter objectives for which map can be prepared. But in name of the religion, the God which is physically unseen, when you can realize it, that's a different thing. Physically, which cannot be seen, which cannot be touched. But for that, the people fight. And not only the fight, so many wars, lakhs and crores of people have been slaughtered on that ground. And that was why the communist Lenin, they say it is an opium. I'm not going because religion, I believe it in the God. It is a necessity because it relates to your inner conscious. Everything in the world is a matter. The Western world believes in the matter, physical enjoyment. But there is inner consciousness, and inner consciousness is only when man believes in his own inner consciousness, which leads to truth, non-violence, love. A man may live. If he is not happy, every material objects will be meaningless. But it must be realized in true speech. Then the question is, what is the remedy for it? Is there remedy? They must come together. The remedy can be seen by toleration. Toleration means you read namaz one side and I chant the bhajan in my own temple. Both permit, both go together. This is a toleration. So everyone, every person who is belonging to different religion must think that he is also performing his own religion. Let him do in his own way. And that is a toleration. You don't like it. But it is not possible. Everyone will do the same thing. It is also not possible that entire world view of the one religion. The Hindus will remain here, the Sikhs and Christians will be here. Everyone will live here. Conversion may be limited, but total conversion is not population. The whole population is. So only the theory is toleration. So that is the one remedy, that the toleration, principle of toleration should be there. The second is to develop the respect for other religion. Very well, you are, Christians are doing prayer in their own way. I must respect that religion also. Ultimately, it is for the God or realization of the God. Or you say, forget about it. The God, word, God. Sometimes it is created more problems. It's its own super consciousness, Buddha says. Buddha doesn't believe in God. But it says supreme consciousness. That supreme consciousness is also a part of inner, which is whatever the matter is concerned. How the world is a matter. And that is the word now today, the difference between religion and is spiritualism. Spiritualism within self, and outside is the matter inside itself. So respect the other. Let him do his own way. Sing bhajan in his own way. Do meditation your own way. Let respect. He's doing, let him do. And he's doing the same thing what I am doing, but my own way, in my own thoughts. Let him do in his own thoughts. So this is the, and third is the education. The education of what? Of human values. So the most important aspect was, and that was well considered, Harvard Law lectures of Rabindranath Tagore on religion of man. It's a very nice lectures. Deeply religious thoughts, what Rabindranath Tagore could have. I'm not going to that, it will take time, and it is not my subject also. But I may tell what he said. That divinity and humanity are two faces, but of the same coin. A person should be human values. He must have a humanity. A divinity will have no meaning unless there is a humanity, and humanity will come from divinity. So the humanity is the most important part, and that is humanity is the religion of man. And that is also the United Nations always used the word human, beings, human. And beings, human means love, affection, brotherhood, non-violence, helping others, truthfulness, whatever the goodness of a thing is, that is the humanity. Otherwise, what the other part is beasts. The human and beasts, the humanity will come when you have a divinity, and divinity will come when you have a humanity. So as the Human Rights Day is observed on 10 December, there must be a Human Duties Day of the world over, and that must emphasize on the humanity, and that humanity, if remain there, then the religion will have its meaning. And I hope and request for the authorities to consider this, and that Human Duties Day be observed all over the world, institutions and everyone, where everyone should live happily and make India happy. That is all. That thank you very much that you invited me on this subject.
Thank you so much, sir, for your enlightening words. Um, if you have time, would you like to take a few questions from the attendees?
I couldn't understand.
Sir, would you like to take a few questions from the attendees?
Yes, yes. Anybody can ask any question.
Sure, sir. I would request all the participants to post their questions in the chat box and I will convey them to sir. By then, Abhin has a question and he would like to ask himself.
Good evening, sir.
Good evening.
Yes, my question is what were the religious values and sentiments that you had kept in mind while practicing as a lawyer? And did it get any different when you were elevated to the position of a judge?
No, there is no difference. As a lawyer, I have to argue whatever the matter is briefed me. I have, as a lawyer and as a judge, there is a lot difference. A lawyer is to argue the matter, the brief, what he has got. He doesn't have to decide, judge, and correctness. So Dr. Kailashnath Kaju, when arguing a matter, the judge put a question. That was a criminal case. Have you asked your client whether he actually murdered or not? Said no. Once I ask this question, he says that he has actually murdered, and I argue here that he has not murdered. Then I become the witness. So in my life, I've never asked any question as the reality what happened. Whatever the matter is on the record, I argue it and argue it as a lawyer for a client. So I have nothing to do. And a judge, when I have to decide it, I consider both the aspects as my judge, duty to judge it.
Thank you so much, sir, for the answer. Karishma Kumari is asking, there is no authority on the kind of evidence that is to be considered authoritative for the purpose of determining essentiality while determining the practices that are essential to a religion. From what has been seen in the past judgments, do you believe that the test of essential religious practices needs reconsideration?
Which case?
So she's asking, do you think that the test of essential religious practices needs reconsideration?
Reconsideration is concerned. It is a matter to be decided by the court. I have nothing to say. It is a sub judice.
Thank you, sir. Next question is sent to us by Aliza. Sir, your views on the very contentious Gurugram Namaz in the open space. There has been a very sharp opposition of the Muslim community offering namaz in public space, and the issue is now highly politicized. From a constitutional perspective, do you see the requirement of intervention of the state in it, either in facilitating the prayers or prohibiting the same?
No, his clear answer is Article 25(1) of the Constitution that says, subject to the other provisions of the Constitution, health, public morality, public order. So if the state is nothing to do with the matter of religion, but it has to see the public order, whether it is justified to offer namaz in a public place or not, how it's to be regulated, it has to be examined by the state in relation to the public order. It will not say offer namaz or not to offer namaz. The only question is place, whether it creates any public order or not. And if it is there, how to reconcile. It is a matter for the government to consider.
Thank you so much, sir. Nadia Murshid is asking, the Daudi Bohra community practices female genital mutilation under the pretext of freedom of religion as fundamental right. However, this particular practice is violative of right to life and specifically right to health. As reports by WHO portray the harmful effects of the practice. Sir, how should a balance be struck between people's right to practice their religion and their right to life, if something of this sort is considered?
Now it is a matter to be considered with the court because what are the rights in relation to the religion is concerned. The basic is that I have religious right. Now, what that religious right is, that has to be subject to that other provisions, public conscience, good and welfare and all. That has to be examined in each case. I have narrated so many cases, different views, different aspects, in a one not particular watertight compartment. It has to be considered by the court, considering various aspects.
Thank you, sir. Neil is asking, recently, a draft Lakshadweep Animal Preservation Regulation 2021 was promulgated that imposes a minimum punishment of 7 years in jail for selling or buying beef products. This obviously caused a furor in the Muslim community in that religion, as beef is their staple. In this regard, how can a diverse country like India reconcile varied religious beliefs and practices if the practice of one religion is not supported by some other religion?
Now, so far the beef is concerned or the cow slaughter is concerned, the states have framed the laws. If it is violative of the laws, then the action will be taken. If it does not violate the law, that is not. Now, certain states have not framed that law. In Bombay, cow slaughter is permitted. UP, it is not permitted. So it is what the law is there. Then that law is justified or not, that is another question. But if that law is there, then it has to be enforced. And the Supreme Court has also upheld the cow slaughter cases. That so far, if the law is there, then is not permitted. Because in that case, the Supreme Court particularly, the argument was that under the Muslim personal law, it is permissible to slaughter the cow, particularly on Bakrid Day. Now, Bakrid Day, Muslim is to offer a bakri for slaughter. It is a duty. But they say that if a goat is not available, then in that case, they can slaughter a cow. So this was the argument. The Supreme Court rejected that contention that even under the Muslim law, it is not compulsory. It may, but it is not compulsory. So that part was rejected, and the Cow Slaughter Act was upheld by the Supreme Court. So what the Supreme Court has decided, one cannot go against it. So feeling is the different thing. I've just said that every religion has some feeling, a different one. Idol worship, one accepts, then doesn't accept. So Buddhist doesn't accept any idol, or they don't accept even the God. So everyone has a different. The feeling has nothing to do. We have go by law, what the law is and validity of the law. The Cow Slaughter Act is concerned, it has been upheld by the Supreme Court, and if it is the law of the state, then it has to be enforced.
Thank you so much, sir. We have Neil Tulsiani and he would like to ask a question to you.
Good evening, sir. So my question to you is, what is your opinion about the anti-conversion laws? So do you believe that such laws are actually freedom of religion laws?
No, Article 25 itself provides that everyone has a right to profess and propagate religion. Now, so far propagation is concerned, it includes the conversion. So there is no dispute under law that conversion is not permissible. What is prohibited is forced conversion. And there are many cases, you will find it in the number of cases I can give you, that forced conversion is not permissible, but conversion is permissible. What is important is, under the Indian Constitution, that you can propagate religion. Under the Russian Act, they have a fundamental right to propagate, and that there is no religion. You can propagate that there is no God. That is the theory of the communist. But under the Constitution, under Article 24, everyone has a right to propagate his religion. He can propagate. And propagation, further extension, propagation, what is the effect? He thinks that you are right. He thinks that your thoughts are correct. And then he agrees with you, and agrees with you, you say it's converted. Then conversion, that some ceremonies may take, that's different thing. But the conversion is of the thoughts. Conversion of one's turn to be Muslims from Hindu, it means he believes that idol worship is wrong. First he changes his mind. If he leaves, converts thoughts, the way of life is different. The system is different. So he believes it and then converts it. So there is nothing wrong in the conversion. It is a result of the propagation. The conversion is not, it is permissible.
Thank you so much, sir. We have Tanish, and he would like to ask a question to you.
Good evening, sir. Am I audible to you?
Yes, yes.
Sir, I just wanted to know your views on the Uniform Civil Code, considering that most religions actually aim for a religious autonomy. Do you think there can be a balance that can be struck between Uniform Civil Code and the aims of all the religions?
Now, that is why I said that earlier when the question of the fundamental rights, this Sabarmalai case, you read the judgment running about hundreds of pages, the very discussions on that. That is the further question that you are asking. I apprehend that was the question that may be raised in regard to the, because Uniform Civil Code is only in Article 44, in directive principles. Now, directive principles are not binding as it is only direction. Now, civil, it is a matter of the personal laws. Personal laws, how can be interfered? That is the question. Now, so far Hindus, personal law has been interfered. Old Hindu law is different, not totally different, but many aspects is totally different. The question of the divorce was unthinkable in Hindu law. Once marriage is a marriage, it is a sacrament in life. But the concept of divorce has been introduced by Hindus, Marriage Act. It is interfering in the personal law. One can say, what type of, I was married in a Hindu customs. Now you enforce this concept of the divorce. So the state government or the state or parliament, whatever it is, it's changed the personal law. Shah Banu case in regard to the Muslims. Now, Shah Banu case, this was the argument. Muslim law does not provide maintenance charges. There was hue and cry. Because it was judgment of the Supreme Court, matter could not be referred to anything further Supreme Court. But the law was changed. So, Shah Banu case another. The next case is triple talaq. Parliament passed the law. It has not been challenged. It is interfering with the personal law also. Now, with respect to the Persian law of personal law, Christianity personal law, there is no occasion to decide any particular questions. So, that is a question when the Uniform Civil Code is imposed, then it will be considered. But it is a question, a broad question, still open to be argued. In 70 years, more than 70 years has passed. The Supreme Court has directed to pass a uniform civil code, but it has yet not been done. And if it is passed, then certainly the various questions that I demonstrated before you will again be considered. Anything further?
Thank you so much, sir. Samriti Sharma is asking, sir, can you please explain the word dharma and its value in the constitutional philosophy and India's legal system?
Now, the word dharma should not be taken as the word of religion. Once you take the word as a religion, then it confined to a certain groups. Dharma is a Vedic word because there was no religion at that time. A time when no religion. So they use the dharma. Dharma means whatever is support. You want to support. You support is the theory of Kelson, philosophical theory. Austin says law is a command of the sovereign. Kelson says, no, you are wrong. If you play a cricket, your wicket falls down, you say, is it right? But supposing on that day, no, it doesn't matter. I will not take it as a correct. The game will be over. If football is a goal is there, you don't accept it. So we'll look at the game is over. So what is say dharmo rakshati rakshita? If you protect law, law will protect you. So what he says, dharma means support. If you want to support, dharmo rakshati rakshita. Dharma means only to support. Satyam vad, dharmam chara. These are the certain values. You speak truth, you respect your parent, you respect truth, violence. Ahimsa paramo dharma, satya paramo dharma. So these are, what they say is not in the context of the religion. What the religion word is a word of the Western thought. Where the question of the religion, there is no word of religion in India, in any Vedic terms or anything. Even a Muslim don't use the word religion. Buddhists don't use the word religion. Buddhists use the word dharma, sangam dharma jayati, dharmo jayati. So they use the word dharma. Jains use the word dharma. And Hindu religion, actually Hindu word is nothing. Hindu word was used by Alexander. They couldn't use the word he. So Sindhu used to cross the Sindhu river. That was the region. So Hindu word. Hinduism, nothing. They say, Hindus themselves says, is a Sanatan Dharma. Sanatan eternally is concerned. The period that is given is 10,000 BC. So certain scriptures written 10,000 BC. You may not take 10,000, even 5,000 something. But it's coming down. Certain. So they at that time used the word dharma, that which supports you. Now today, the dharma has been obnoxious word. When you use the word dharma, it is taken an obnoxious word. It is correlated with religion. It has nothing to do with the religion. Nor Hindu has nothing to do with it. The dharma is nothing but a support, is a philosophy, is a thought. So if you support it morally, if you commit a theft, the other is also prepared to theft. Then the robbery, then the dacoity. So this will go on. So avoid and check it. They frame the rules, and you, who's first created the law, created this all, is only on the basis that it is the dharma. If you accept it, you will be happy. If you don't accept, you will be unhappy. No, it will create problems. So that is the dharma is concerned.
Thank you so much, sir. Here, I would like to thank you for gracing us with your presence. It was indeed an honor for each one of us to learn from you on the topic religious values under the Constitution of India. I would request Aliza to give a formal vote of thanks.
Good evening, Mr. Agarwal. Sir, on behalf of Informal Discussions Group, I, Aliza Tariq, would like to express my sincere gratitude to you. We are extremely honored that you graced us with your presence today. It was a privilege for us to have interacted with you, and I'm sure each and every one of us is taking away something extremely valuable from this very insightful session. I would also like to thank you for enlightening everybody present here on the realms of religious values under the Indian Constitution and more. I would also like to thank the members of the committee who contributed in making this session a success. I would thank the members of faculty and other attendees for their graceful presence and bringing up such a wonderful and relevant questions. Thank you very much, sir.
Thank you. Thank you very much that you invited me to be with you all. I always wanted an opportunity to meet you all in the university, but certainly couldn't get a time or opportunity. Today you have given me the opportunity to be with you. I'm thankful to all of you.
Thank you so much, sir. Aliza, over to you.
A very